Well, beneficiary beware there, because once they're deciding not to do an administration, they're putting themselves out there as being liable if there is a creditor with a valid claim.
Yeah.
Adrian, does that case apply when it's a beneficiary on a POD or even a right of survivorship?
The only thing I'm aware of for PODs is bank accounts, and you have to prove that the estate is insolvent before you can claw back the funds from the bank account. Yeah, so too, Susan's saying about the mineral interest, if there's other property out there that, makes the estate not insolvent, then you probably can't go after the bank account. And then I feel that what I've done in the past is make a claim. So if I'm representing someone who has a valid claim for funeral and expenses, go ahead and make the claim into the estate. And then it would be the executor administrator's duty to, if it's an insolvent estate, to exercise that statutory authority to go and make a claim against the bank account or the recipient of the bank account.
Very good. I was hoping that we would have some discussion of some of these things, because this is kind of it's really a very large area, and there's a lot of confusion about what you can do. And a lot of estates don't want to do it. Then some estates want to do the notice to creditors. A lot of times by approaching the creditors head on is by giving them notice is probably a good way to do it, just because you deal with it. And if you can, you still may, I'm not sure it completely wipes out your liability if you're the transferee, though. I think that they still come after somebody later. But the probability is, if they want to collect something, you've got a better chance of collecting it from the estate than you will from the beneficiary later on, typically speaking. So you would think that they would go after the estate first. I mean, just as a practical matter, not saying that they do, but just as a practical matter, it seems like that would be logical to do, but they don't have to. Yes.
And as a practical matter, it has to be a pretty large asset and a pretty large debt, because the creditor has to bear the expense of the lawsuit to go after it, filing the estate to go after it. And so they're incurring some fees here that they might not get back if it doesn't work out the way they want. So that is a deterrent that I've seen. A lot of them don't bother because they're going to have to spend money to try to go after that money. So it's going to have to be significant amount of funds to justify attorney's fees.
Yeah, that makes sense.
I agree, or kind of ditto what Shauna said. I had a probate a couple of years ago, and the wife had a lot of credit card debt. I mean, not millions, but 30, 40,000 or something. And maybe even more than that. It was a good bet. And most of it went paid on debt. We paid a little bit of things, but it was basically insolvent. And there were 2 or 3 credit card companies that because my opinion at that time, after talking to Shauna, it seemed like to me that he wasn't liable for it. And so I wrote letters, I included attachments. None of the 3 credit cards ever came back. I mean, they came back and said, show us why he doesn't know it. Show us I think they had to apparently verify with somebody above them, but I mean, they didn't do it. And I didn't even send permissive notice. I mean, credit cards are after you anyway. I mean, they know anyway. So I've always never had an issue having to, tell the benefit that they've gone against the beneficiary, I should say.
That surviving spouse situation, though, is unique because a spouse has a duty of support on any contract for necessaries. So, I mean, I think Featherstone has a great paper out there about this that says, arguably, a creditor could come after 100% of the community if it's on a contract for necessaries. So you have to.
And I think, they just didn't go through the credit card. Who knows what it was all for, but who knows, but they never even got to that point. So, but that's a good thing to know about. I remember that thing about necessaries, which could be food and health and stuff like that. I think the credit card people must build enough insurance to be able to handle these that it's not worth, like Shauna said, it's not worth it.
Yeah, I think definitely they're finding it not worth it. And there's cost involved in doing it, but also they probably want to spend their time where they get the biggest bang for their buck too. And if it's just small amounts of money, it's much better to spend it on something that's bigger. And what happens with some of the banks almost instantly turn it over to collection agencies. And when they turn it over to the collection agencies, it's my understanding that a lot of times that's being sold and it's just for a very small amount. And so the collection agencies just need to collect something, but it may not always be sold, but a lot of times I don't think that, I think the bank's gotten whatever the bank's going to get. And it's moved on to the next stage of collections.
And it's not always just banks. I had a case where an alcoholic client died with a $45,000 hospital bill, not covered by insurance because it was related to her alcoholism. And the sister wanted to pay some of it, but not all of it, because she thought Baylor didn't do a good job of taking care of her sister at the end. I spent 2 years trying to send emails or get a hold of somebody in the Baylor collection department to give them $15,000, which was in the letters, and no one ever got back to me. When we got like one name, I sent them letters. So after a couple of years, I stopped trying, and after 4 years, the debt went away. So, that was a pretty sizable, it wasn't like $200 or $300, and they never even, either they were so disorganized or it was still too small for them to be interested. So she never had to pay it, and she wanted to pay it. So it's amazing how some of them won't even try to, make a deal with you so you can pay them and get it off your list.
Yeah. And I think that there's a lot of that experience out there that among attorneys that when you give permissive notice, a lot of times you never hear a word, never hear anything at all. Well, to get any other comments? We're going to go back. What I also have prepared is, how claims are made in an independent administration. And so I think we'll just skip on to the permissive notice section, because permissive notice is kind of where people do a lot of permissive notice. And there's a specific procedure that you need to go by if you haven't done the permissive notice to creditors yet. And it's in section 308.054 that you can give notice by registered mail, and that they must present the claim within 120 days after date of receipt. Otherwise, it's barred. One of the purposes of doing the permissive notice is to put the estate at rest, and so take care of the claim, notify the creditor, pay it if you need to pay it, or if they don't respond, you don't pay the claim. But it's a means of getting, it gives more assurance to the executor when they pass out the estate that they've tried to notify everybody that there was debt, and that make their claim and to present it to you. In the process of it, when you have a notice to creditors, there's specific things you need to tell them under that code section, and that you have to give them the notice by certified mail, and then you need to be sure you give them the date that you got letters testamentary. And that, I think that's partly for the statute of limitations reason, because the statute of limitations is 1 year after death or when the executor was appointed. And then you've got to, they can provide the claim either to the personal representative, to the executor or administrator, or to the attorney. And so you give them an address where to make the claim. And then you have to instruct them that it needs to be in compliance with section 403056. They include a sentence that says, I've always seen it recommended to include a sentence to the effect of, a claim may be effectively presented only by one of the methods prescribed under the Estates Code 403.051. You could, of course, accept it another way, but ideally you do not want to accept it except if it's been presented as set forth in the code section. And that means they have to send it to you, certified mail, and they have to have certain magic words in their claim. And the problem that creditors have is they don't want to send it certified mail if they can just mail it to somebody, but they're supposed to do the certified mail. And then the magic words is that all legal offsets, payments, and credits known to the affiant have been, or that the claim is just. And I've gotten a claim recently, and it says everything else, but it doesn't say the claim is just. They said it was fair, but they never said it was just. And I think that the courts tend to be pretty much a stickler for having it saying the proper words, and the proper words is the claim is just. And so that also has to say that they have to tell you that all the legal offsets, payments, and credits have been allowed. So when you look at a claim, if you get a claim from a creditor, save your envelope, and then keep a list of what you got and the date that you get it. But make sure it says the words that are required in the statute, because if they're not saying those words, they're not making the proper claim. And so you want to be sure you're dotting your I's and crossing your T's. The one thing I found is it's funny how it's the little things sometimes that'll get you. And on a credit receipt, on a credit card statement, there's more than one address. And so I look at those addresses and I go, well, which address is better to send it to? And so sometimes it's confusing on terms of which address you send it to. And I've never seen that addressed in terms of whether anybody, well, they send it to that address, but we were over at this address. And yes, they were both on the statement. I don't know if it would matter if you pick one or the other. If they make any reference to, if you have any disputes, give it here, that I usually would send it to that one. But sometimes it's hard to tell that, but they may have two different addresses. There may be one on the back of the credit card and another one on the statement. And I'm a bit at a loss on which one would you want to send it to. I've tried to make a logical choice, send it to the logical, what appears more logical to me at the time, and go for it. One time a creditor had asked for a copy of the inventory. I mailed them the inventory and I sent the letter to the same address. I thought, well, if they're asking for stuff at that address, it would have to be a pretty good one to use. It's best if you can avoid talking to the creditors, but that's not always easy to do. And if you're a solo, you answer the phone and there they are. So you can't necessarily have somebody. You can't have somebody else in between you that'll screen it for you. But so sometimes I do talk to them, but I try to be very careful in what I say. And so anytime you have creditors or any estate, just be careful what you say, because the first thing they tell you is, oh, by the way, we're recording this. I don't know if they do or not. They probably do, but I can't imagine them finding all those recordings if they recorded every conversation they had. But who knows, maybe they do. Maybe they find it, maybe they love to keep up with stuff like that. But just they also they have to give you the information on that the claim is founded on a written instrument on account, and the facts on how the claim is founded. On a dependent administration, it's a little harder. It's probably harder for the creditors, because with a dependent administration, you cannot accept any claim, because if you've accepted it improperly, the court may not accept it. So it gets a lot harder for them to get through all the hurdles of a dependent administration. So if you had an estate with a lot of debt, they may want to just do a dependent, even if they've got a will. And even though that's a lot more work to do that, it still may come out better if there's a lot of creditors. There's a lot more hazards with a dependent administration for the creditor. And I thought it was interesting that you mentioned the medical claim and you offered to pay the $15,000, because I've come across that same issue. It's like, well, which one do we pay? And sometimes there can be you could need multiple different medical providers. And some of the medical ones, they're not responding. Some of them are not accepting the letters, and the whole letter comes back. And so I think maybe they must have gotten some where they found out that they had claims in them, or people asking permissive notice. But I've had some of them, more of those come back without anybody ever receiving them than with other creditors. That, in my experience, just for what I've done. Under a dependent administration, you still are looking mostly at the unsecured creditors, and you're not looking so much at the others because they've got some security that they can get to, and they've got some priority. The personal representative cannot accept a claim that's not properly presented or is not supported by a proper affidavit. And they also, when the dependent administrator does the permissive notice, even though they're kind of dependent and independent are under different kind of code sections, they still use the same format as that permissive notice to creditors. And on a dependent administration, another fact is that the creditors cannot obtain a judgment on the claim until they first present it to the personal representative and it's disallowed. Now that can get a little bit tricky in terms of disallowing. A lot of times at the beginning of the estate, it's hard to know what you've got, what assets you're dealing with, what debts you're dealing with. A lot of people, I've had clients that say, well, we have one credit card, and then about 4 months, 5 months later, you find out there's more like 20, and you don't know that. You would think they would have known it at the beginning, and who knows. If it's not a surviving spouse, if it's a friend or whatever, they may not have any idea, and they may think there's only a very limited amount of debt, but they find out as they go along that there's more. But they have to present a claim, and it must be authenticated still and by affidavit, and then you've got 30 days to file a written memorandum to the court to either accept or reject. And if you do nothing in that 30 days, it's deemed rejected. And one of the things that I haven't figured out yet on all of this, I've made notice to it, but what do you report to the dependent administration? What do you report to the court? That you can do that. You don't have to have permission to give the notice. But when you've got the claim and they've never answered it, I've not seen anything particular that says you have to tell the court these facts. And so I haven't figured out exactly what you have to tell the court to. I've put it in the annual account that these were presented and that they weren't paid. Or they were not claimed, and no claim was filed, and the days have passed. And I've put it in annual reports. I don't know whether we should put it in also in another document to the court. Has anybody had the experience with a dependent administration on the permissive notice that has not been responded to?
I don't have an answer to that question. But I was wondering, when you do your application to close an estate, whether you'd also be obligated to put something in there in closing.
That's a good question. I would think that you would. I mean, you have to do a final annual account, and like I said, I put it in my annual account so that they know that's something that happened during the year. But I would think that you would probably want to. I think it would be safer to put it in than not. So I would think you would. I've just wondered if there ought to be a separate thing filed, and how much information do you give the court on that, since it's a dependent administration. And I don't have a good answer. I've got to call into one of the administrators, and so I've got that as one of my questions.
But then would you be required to give notice to that creditor?
Well, yes, if you've given notice.
Well, no, of the filing saying that the period has passed, or that you gave them permissive notice and you got no response.
Oh, you mean follow up with another letter to the creditor that notice?
No, when you file with the court, a report,
Yes.
you obligated to serve a copy on the creditor? It's been mentioned in it.
That's a good question. That's a good question. I don't know.
I wouldn't want to.
Yeah. I mean, you've already given them notice once. Why would you have to do it the second time? That's a good question. And that's what I've tried to figure out. How do you close that out completely? And I'm not sure I've seen anything that talked about that. You know, it's fine to say, oh yeah, they won't respond. Everything's great because then you don't have to pay them. And it's a dependent administration. But that next step of, okay, but how do we really, it just seems like it needs to be wrapped up somehow. And like I said, I put it in my annual report, but I haven't done it as a separate filing. And I don't know if I gave adequate information, just maybe I did, maybe I should put a little bit more. I was questioning how much I've put in. And so I'm going to talk to one of the administrators and see if I can find an answer to that, because I think that would be a good thing to know. And I didn't know, I haven't done, other than telling them in the annual account, I haven't given them separate notice of having it been done.
My understanding, as long as you have proof that you sent the letter, the notice to credit, the notice or the secured notice letter to the creditor, if you have that green card, I think it's done. If the creditor doesn't file their notice and that, then you're done. I think, and when you do your annual account, you just state that you have a green card, you attach the copy of the green card, and if they're barred, they're barred. I mean, that's how my recollection of it works.
Did you give a copy of the green card to the court too? Did you file that with your report?
I think we did.
Yeah.
I was going to say, I've done the same in an annual account. And then when I got to the final account, I, listed each creditor that received notice, the date, and whether they responded or not. And then ended it with stating that the claim was barred. And then I had the same language in my order. And so I've got an order saying that each of those claims were barred for whatever reason, based on whether they responded or not. So
yeah.
And if it's a dependent, I think you need to get an order from the judge denying the claim.
So I made sure I had that in my order on my either my annual account or final account, wherever I am in the process.
There's so many little things that, maybe everybody's supposed to know all little details. Oh, if only I did this or that or the other, that there's a lot of little, there's always something to think about. And there's always one more step you can take a lot of times. And sometimes you take just too many steps, but it's better to be over-inclusive than under-inclusive for the most part.
Especially in a dependent administration.
Yeah. Okay, let's see. Now, one of the things it says, if you reject a claim and then the creditor has to file, sometimes they can try to get you for cost of that. And I don't know how much of a problem that has been, because a lot of times I think if you've got the 30-day period, when just on the regular claims, they've made a claim, you don't respond, the 30-day passes, and then if they push it further, that you have to pay them costs for them to sue you to get the money. I haven't really seen much of that. As I guess it seems to me there's not as many creditor lawsuits as one might expect, I guess. But there is in the code that there can be costs taxed against the executor individually if they improperly reject a claim.
Wouldn't it have to be approved by the probate judge?
If in a dependent, I guess it would have to be, yes.
So I don't know that the probate judges are too keen about charging the estate's fees.
That's probably true. That's it, again, to go into the practical matter. Well, some of the things, and then I've got the next part of my outline. We talked about some of the things to do in terms of when you're making a permissive claim. And part of that is to make a schedule. And I included a copy of the schedule that I had just, I looked at several of the ones in the CLEs and stuff, and kind of a schedule that I've used to find the information so that you collect that information. And so that you have, who you sent it to, what the address was, the amount owed, the class of the claim, the date that you sent your letter, the date that they received it, and the deadline to respond, and then if there's any other comments. And so if you just get some kind of sheet like that, you can keep track of the different creditors and who's responded and who's gotten the green card. Now, during COVID, I actually got a green card back that somebody just wrote COVID on it and sent it back, which makes me wonder who did that. And I have no idea who did that. I don't know whether it's somebody named COVID at the credit card company, although I doubt it.
The post office is writing COVID in there. It's an excuse so the delivery guy doesn't have to go to the front door.
Yeah,
and I've gotten a whole bunch of them, and who knows what that means? I don't know.
That was my next question. And so what does that mean? So do we send it again? And when I got that, it's like, okay, that's what I assumed it was, is that they didn't want to deliver it because they don't want contact. And you can't really blame them. There is I put a part of the Reptil's most recent, let me see what they call it. Their CLE, it's not really a CLE, but their paper from Saunders Norval, the one they called Face Masks, Zooms, and Quarantines. This was as of May 3rd of this year, so just not very long ago. They keep these on the status of the Reptil matters. They keep them on their website. And so you can go to Saunders Norval and, they update it periodically. I don't know how often, but they tell you a lot of things that are coming up that are in the probate code and the things that they're looking at, which has been interesting. And one of the things that they've talked about, and I believe it's in this one, is they want to give you alternative ways to give notice. And alternative ways to send it. Right now, it's been the post office, certified mail return receipt, but there's other services. You've got FedEx, you've got other things. And so they have a bill out there to try to let you use a different service. The problem is who has this, does somebody, I think with almost any service, you can have somebody sign. So you can make any service where somebody's supposed to sign. But I'm not sure how it's going to work with all the other services. It's a little different. It's going to be a little different on the formatting. You're not going to have a green card. You're going to have your paper that you filled out for FedEx or for UPS. And then if they get a signature, which sometimes you give signatures to them, I don't know how you get that signature back. You probably can go online for it. But they are looking at giving us different ways of giving notice, and instead of certified mail return receipt requested, and partly because I guess so many people have complained about that there's some beneficiaries that will never pick up their certified mail. If it's certified mail, they don't want it. I don't know how it's going to make it better to be something else, though. And then a lot, as I've just been left with questions and on different creditor things, and a lot is like, where's my green card and what do you do? And you can go online and you can confirm you got the green card, but I don't know if it's not like they have a copy of it. They just tell you, and I have been meaning to look up on a couple of them recently anyway, just to see if they indicate that it was signed or not. And I don't know if that would be helpful with the court. So I think that's about all I've got really on the creditors. I hope that we've learned something new, and I've learned a lot just in preparing this, but it's been an interesting topic, and I still have questions with it.
Alicia, that was awesome. Thank you. I don't actually have a checklist like this for permissive notices. So I'm like, oh, this is going to work really well. This is good.
Well, good.
I'm kind of hit and miss, but this is good. A nice little checklist you put in here. I love that.
Well, good. I'm glad it can be something useful.
Thank you for doing that, Alicia. And Mona, do you need to talk about SWAN before
with 30 seconds left, I want to say that our next time is July 9. That Monday is a national holiday. Want to make sure that nobody has a problem with us still meeting on that Thursday. So let me know. Also, let me know if there's any takers. I'm looking for a facilitator for that date. Alicia, you gave us a tremendous amount of content and a lot of helpful information. So thank you.
Well,
Mona,
thank
the 9th is a Friday. Do you mean
Oh,
July
8th,
the 8th?
8th. I'm sorry. I'm looking at the wrong date, July 8th. And the following date is September 9. That's why I had 9 on the brain. Sorry.
And right before we go, we had somebody, 2 people that signed in that didn't get to say, and they're relatively new, Roxana and Wynthia. Would y'all just give like a 2-sentence thing about what you do and where you are? Roxana, you go first.
What I do, I think what everyone else does, estate planning and probate. I just started my own solo practice, but previously worked with Larry Wolfish and Lisa Newman and Alicia and Susan Morris. Hi.
Hi.
So thank you for Susan for facilitating my invite to this group, and I look forward to joining all of you. Oh, and Mona too. I've worked with Mona too. So thank you.
And
Welcome.
Wynthia?
Hi, I'm Wynthia Cheatham. I've joined before, and just for a refresher, my practice basically is estate planning, probates, trusts, and I have a background in oil and gas. I want to thank oh, she left, Miss Grace, for a referral that she gave to me, and I'm sorry I missed half of it. I was on a call, and you just can't get off. I don't know why people won't shut up. So, but anyway, yeah, I plan to continue joining the meetings, and I've really enjoyed. And the little part I did get, it was insightful, Miss Lively. So thank you very much.
And
Mona.
thank you. Wynthia, also thank you for introducing Glennis to us. Glennis, if you could email me your little blurb, but Roxana, I copied yours down. I send out a spreadsheet of everybody's contact information so that hopefully in between our meetings, which is every other month, you can be in contact with each other. This group has grown, as I said, we're going to be 2 years in August. And we're really pleased. There's a lot of people that couldn't be on the call today. So they know they missed something good. Alicia, thank you again.
Oh, thank you.
Appreciate you. Everybody stay safe and well. And thank you. Keep referring us. We always want new people around the table.
Thank you. Bye-bye.
Have a great day, everyone. Be well.
Bye. Thank you.
Thank you all.
Thanks again.
Thank you.
Bye.